Hello, my name is Keisha Lovelace. I'm a Deputy Commissioner with the North Carolina Industrial Commission. The Industrial Commission is the state agency that administers the North Carolina Workers' Compensation Act. This presentation is designed for employers to provide general information about your obligations under the North Carolina Workers' Compensation Act. Before we begin the presentation, please note that this presentation is for general information only. If you have any questions about the particular circumstances of your business, please seek legal advice, and you may also get general information from our information specialist. That information will be presented to you at the end of the presentation. Please also be aware that this information is subject to change due to changes with workers' compensation legislation made by the North Carolina General Assembly or through changes made through the Administrative Procedures Act to the North Carolina Industrial Commission rules. At the end of the presentation, you will be provided with our website where you can find more information and up-to-date information about workers' compensation rules and laws in our breaking news and announcements section on our web page. First, generally, any employer that regularly employs 3 or more people must have workers' compensation insurance. When I say regularly, that means that you have people working for you with some consistency. There's a consistent pattern to their employment. And if you have 3 or more employees, then you must carry workers' compensation insurance. This presentation will talk more about who constitutes or who is an employee and exceptions to this rule. First, exceptions to the employer rule. If you are a business or if your business has the presence of radiation, you're required to have workers' compensation insurance if you have at least 1 employee. If you're a sawmill or a logging operation, if you have less than 10 employees and you saw and log less than 60 days in 6 consecutive months, and your principal business is unrelated to sawmilling or logging, then you are not required to have workers' compensation insurance. And also, of course, if you're employed by the federal government, your workers' compensation claim is the United States Department of Labor and is not administered by the North Carolina Industrial Commission. There are also certain exceptions that apply to agricultural employers. You are not required to carry workers' compensation insurance if you're an agricultural employer that does not have 10 or more full-time, non-seasonal agricultural workers. And those people are not regularly employed by your enterprise. In other words, if you have seasonal workers who come in during a certain time period, maybe a few months, to help harvest crops and do things of that nature, and you don't regularly employ 10 or more people throughout the year, then you're not required to have workers' compensation insurance. Similarly, if you are a person who sells agricultural products, where the farm boxes the produce together, gives it to you, and you're paid on a commission basis, similar to like a farmer's market, you're not required to have workers' compensation insurance as well. Now, who is an employee? Every person engaged in employment, whether it's via an appointment, there's a contract for hire, or an apprenticeship, whether the agreement is written or oral, express or implied, that person is an employee. It also includes people who are minors under the age of 18, and it also includes people who may not be working here with proper documentation in the United States. It also includes part-time workers, temporary workers, seasonal workers. If any of these conditions apply, then that person is an employee. Now, who's excluded as an employee? Casual employees. Casual employees, someone who is casually employed and they don't perform work that pertains to the regular course of your business. One of the cases that we saw was heard by the Industrial Commission several years ago related to a business who hired 2 people to come in and set up for a company picnic, annual picnic. They were working for about 2-3 days. That wasn't related to their regular business of that particular business. So those people were classified as casual employees and were not covered by the Workers' Compensation Act. Domestic service, people who are directly employed by your household to provide domestic services are not counted as an employee. And then there are certain railroad employees. I'm not going to go into great detail about railroad employees at this time. If you have questions about that, please contact our information specialist. And as I said, that information will be available at the end of this presentation. In regards to your business structure, if you are a sole proprietor, you have an LLC or a partnership, you are not counted automatically as an employee. When you go and obtain workers' compensation insurance, they will ask you whether you want to be included as an employee and be covered by that policy. However, if you are incorporated, you may elect to be excluded from being covered by the policy. The president, the secretary, the vice president. However, you are still counted as an employee. So if you have a very small corporation, you're incorporated through the North Carolina Secretary of State or through any other state for that matter, and you only have 3 people there, one of whom is the president, vice president, and maybe employee, even though you may exclude yourself from workers' compensation coverage, you are still counted as one of the employees, and you must have workers' compensation insurance. We often get several questions about independent contractors. An independent contractor is determined by a balancing test, which I'm going to talk about briefly. The focus is on the right to control and direct that particular person. Do you have the right to control how that person's work is done? Do you govern or assess how the employees do their work as the work progresses? In contrast, an independent contractor is someone who works according to their own judgment. The person for whom the independent contractor is working is only concerned about the results. The independent contractor can hire other people to assist him or her and direct those individuals, and they work independently. In other words, you hire someone to come do some work on your house. You're only caring about the results. That person, whether it's a plumber or a roofer, can hire as many people as they want. Only thing you're concerned about is the end result. You're not directing the daily conduct or the daily work of that particular person. There are several factors we look at. Is the person engaged in an independent business, calling, or occupation? Are they using special skills, knowledge, or training in performing the work? Are they doing specific work at a fixed price or for a lump sum? They're not subject to being fired or terminated because they choose one particular way to perform the project rather than another. That person is not regularly employed by you. Are they free to use assistants as they think proper? Do they have full control over those assistants? And do they select their own time? In other words, they don't have to be there for a set specified period of time at your place of business. As I said, this is a balancing test. One factor may not weigh more than the other, and when those issues come before the commission, we're looking at the particular circumstances of your business and of that relationship, the business relationship you have with that person. A few things to keep in mind. Simply giving someone an IRS Form 1099 does not make that person an independent contractor. We still follow and use this balancing test. Also, having a written contract saying this person is an independent contractor, or I agree that I am an independent contractor, and that having that contract signed by both parties does not make that person an independent contractor. The Industrial Commission, when these issues come up, use this balancing test. If you have questions about whether your business, whether you're properly classifying your employees, please seek legal advice, or if you want more information, call our information specialist. Our information specialists cannot give legal advice, but they may direct you to a person who may be able to provide you with some assistance. There are also special rules governing the construction industry. In construction, as you know, if you're in the construction industry, as you know, you have a general contractor and you may have several subcontractors working on a project. You might have a subcontractor doing plumbing, roofing, carpentry work, different trades on a construction site. If a subcontractor hired or contractually engaged by the general contractor does not have workers' compensation insurance, that general contractor or the subcontractor who hired another subcontractor to work on the project may be liable for the work-related injuries of that subcontractor's employees, regardless of the number of employees that you or the subcontractor employs. In other words, I may be a general contractor, I don't employ anyone, and I may have 2 or 3 subcontractors working on a project. If one of my subcontractors has an employee that sustains an injury, I may be held liable for that worker's injuries if the subcontractor does not have workers' compensation insurance. Similarly, as a general contractor or that first-tier subcontractor, if that first-tier subcontractor hires a subcontractor to work on the project and that second level or second-tier subcontractor doesn't have workers' compensation insurance, then the first-tier subcontractor and or the general contractor may be held responsible for a workers' compensation injury. So you must protect yourself. Under the Workers' Compensation Act, if a general contractor or a subcontractor who engages another person to provide work on a project gets a certificate of insurance from the person with whom you can, or the business with whom you can contractually engage to work on that project. If you get a certificate of insurance showing that that person has valid workers' compensation insurance at the beginning of the relationship, then you're protected and will not be held liable for the workers' compensation injury. Also, the law provides that as a general contractor, you may also, or the owner of a project, you may secure a policy of workers' compensation that will protect all of your subcontractors. Anyone who works on that project, you can get a workers' compensation policy that covers anyone that works on that construction site. In regards to trucking, any principal contractor, intermediate contractor, or subcontractor, irrespective of whether you regularly employ 3 or more people, if you contract with an individual who operates a truck, a tractor, licensed by the United States Department of Transportation, and that person has not obtained workers' compensation insurance for himself, personally, or his employees and subcontractors, then the principal contractor will be held liable as an employer for the work-related injuries of that independent contractor, his employees, and subcontractors. Unlike the construction industry, obtaining a valid certificate of insurance does not insulate you from liability. The exceptions. In regards to the trucking industry, you will not be held liable as an employer if you contract with that independent contractor who is licensed by the United States Department of Transportation, and that person is personally operating their vehicle or their truck pursuant to that license. A trucking company may also get a blanket policy of insurance to cover all independent contractors, employees, and subcontractors, and you may include in your contract with the independent contractor a provision that the subcontractor or independent contractor must pay a portion of that premium. The other way in which you can try to protect yourself to make sure you're working with or entering into contracts with independent contractors who have workers' compensation insurance is to ask them for proof of insurance. Even though it won't insulate you from liability, you can request a certificate of insurance and then send a request to that insurance company that you be provided with a notice of cancellation if something happens, if that independent contractor or subcontractor, the person with whom you're performing work, cancels their insurance. Now, where do you get workers' compensation insurance? One option is to become self-insured. These are your large businesses, major companies. These companies must become qualified to be self-insured through the North Carolina Department of Insurance. The North Carolina Department of Insurance will look at the financial stability of your business to make sure that you have enough financial solvency to cover any workers' compensation claims. You may also become a member of a self-insured fund. The North Carolina Department of Insurance has a list of a number of self-insurance funds in North Carolina. In a self-insurance fund, groups of related businesses come together, pool their money for workers' compensation purposes. One common self-insurance fund is the North Carolina League of Municipalities. Then, of course, you can get insurance in the open market, where you go to an insurance agent and ask them, hey, I need workers' compensation insurance. They will complete the application, they will contact the insurance companies and let you know how much the premium will be and how much it will cost. If you are unable to get insurance because of your risk or because you may be a new business and don't have enough history for the insurance company to determine what a proper premium would be for you if you're a risk they want to insure, then you can get insurance to the North Carolina Rate Bureau. The North Carolina Rate Bureau will take an application, and they work with 4 different, maybe a little bit more, but usually I believe it's about 4 different companies. And what they will do is assign you to an insurance company for workers' compensation purposes. You can get information about the assigned risk pool through the North Carolina Rate Bureau by contacting an insurance agent, or you can contact the North Carolina Rate Bureau directly, and they can direct you to a person that may be able to provide you assistance. Now, how much does workers' compensation insurance cost? I just mentioned history. What happens in workers' compensation is they look at your history over a certain time period. How many workplace injuries have you had at your business? And what they do is they assign risk to different types of industries. For example, here at the Industrial Commission, my job would be classified as a very low-risk job. It's sedentary. I'm sitting behind a desk each day. In contrast, someone who is in roofing or construction, who's working in high places, or trucking industry, which you're on the road, may have several accidents, those industries may be a little bit more high risk than what I'm doing here at the Industrial Commission. So they look at the different industries and assign a risk to it. And then they look and they say, well, this is the standard. And then they look at your individual business. If you come in above that standard, meaning you have more workers' compensation injuries or work-related injuries than the norm or more than the standard, then you will pay a higher premium. However, if you come in below that standard, your premium may be less. They also look at your business employees. Clerical workers, even though you may be a trucking company, for example, if you have someone who's doing strictly office work, clerical in nature, that particular individual employee will be assessed, or you will pay a lesser premium for strictly clerical employees, even though you're a trucking business. Each year, your insurance company will come and do an audit, and they will look at your payroll. They will look at and assess the types of employees you have to make sure you're paying an adequate premium for the risk involved with your particular individual business. And you may be asked to pay additional money to cover your risk for that year. So, in other words, your workers' compensation premium is based upon your payroll, it is based upon your risk, and it is based upon the type of industry you're in. What happens if you don't have workers' compensation insurance? You can face stiff civil penalties. If you are a business and the Industrial Commission learns that you do not have workers' compensation insurance, you can be assessed a minimum penalty of $50 per day up to $100 per day, depending upon the number of employees you have. If you have 50 or less employees, you will pay $50 a day. If you have between 50 and 100 employees, for example, let's say you have 63 employees, you would pay $63 per day without insurance. Once you reach 100 employees, the penalty is $100 per day. If you are a small business, meaning less than 50 employees, with that minimum penalty of $50 per day, that penalty results in an annual penalty of $18,500 per year without insurance. As an individual, if someone has a workers' compensation injury and you are required to have workers' compensation insurance and you fail to have that insurance, if you are a person responsible in that business, in other words, you are a person who could have brought them into compliance with the act, meaning you were the person who should have been going to get the workers' compensation insurance, you can individually be held responsible for the cost of that workers' compensation claim as a penalty. The cost of the workers' compensation claim includes wage benefits, and it also includes the medical costs. In serious injuries, and heaven forbid in cases of death, those penalties could be individually assessed upwards of $100,000 or more. If you negligently fail to have workers' compensation insurance, you could be charged with a misdemeanor. If you willfully fail to have workers' compensation insurance, meaning you were aware that you were supposed to have workers' compensation insurance and you didn't, you could be charged with a felony and be imprisoned. Please contact a lawyer or insurance agent if you're unsure of your responsibilities as an employer. Finally, if you suspect someone of engaging in workers' compensation fraud, please contact the North Carolina Industrial Commission Fraud Section. They will go out and investigate and open a case and see and assess whether that employer is not complying with the act, and will also investigate instances of individuals who may be fraudulently seeking workers' compensation benefits. Contact information. You may contact our fraud section by calling 1-888-891-4895, and you may contact our information specialist at 1-800-688-8349 and selecting option 3. And as always, you may visit our website, www.ic.nc.gov. Thank you.